Morning, Miss Rachel. It's your day.
Thank you. Apparently, I've just been served a notice for a writ. An acquaintance in Malaysia suing me. Can they even do this to me?
Three fundamental legal principles govern Malaysian court's jurisdiction over a non-resident defendant.
First, jurisdiction is conferred on the court by Order 11 of the Rules of Court 2012, hereafter referred to as ROC 2012, or Section 23, Subsection 1 of the Courts Judicature Act, hereafter referred to as the CJA.
Second, when determining whether it has jurisdiction over a non-resident defendant, the court must assume that the plaintiff's allegation in its statement of claim is true.
Thirdly, once jurisdiction has been established, the court must then determine under the doctrine of forum convenience whether the Malaysian court is the most appropriate forum for the claim.
It is an accepted principle that granting leave to serve a writ out of jurisdiction demands careful consideration, as it may impose an undue burden on a foreign defendant by requiring them to defend their rights in a foreign court, as clearly established in the case of Society General D. Paris. In Limited and American Dynamite, the court noted that serving a writ outside the jurisdiction interferes with the sovereignty of another state, and as a matter of international comity, such service should only be allowed if it strictly complies with the procedural and substantive requirements of the law. This is because granting leave for a service of an originating process out of the jurisdiction is considered to be an exorbitant form of jurisdiction. Hence, by comity, which is the mutual recognition and respect of the laws of every country, dictates that judicial discretion to grant leave for such services is carefully exercised as per the House of Lords and Amin Rashid Shipping Court.
In Malaysia, the service of an originating process out of jurisdiction is governed by Order 11 of the Rules of Court 2012. This provision outlines the circumstances under which Malaysian courts may assume jurisdiction over foreign defendants and the procedural steps to be followed. Order 11 Rule 1 specifies that the court's leave is required for service of a writ outside of Malaysia. The circumstances under which such service is permissible is listed in paragraphs A to M, and these categories are exhaustive. Therefore, an applicant must show that their case strictly falls within one of these grounds, both substantive, meaning the grounds in paragraphs A to M, and procedural, meaning obtaining the court's leave, requirements must be met before a writ out of jurisdiction can be validly served. One point of contention that has been brought forth in the Malaysian courts is whether the courts may exercise their jurisdiction on a foreign defendant under Section 23(1) of the CJA in view of the circumstances prescribed in Order 11 Rule 1 of the ROC 2012. The Supreme Court in Malayan Banking Berhad and International Tin Council held that Section 23(1) of the CJA also conferred Malaysian courts extraterritorial jurisdiction over a foreign defendant, in addition to Order 11 Rule 1 of the Rules of High Court 1980. Take note, service out of jurisdiction in Malaysia used to be governed by Order 6 Rule 6.1 and Order 11 of the Rules of High Court 1980, alongside Practice Direction Number 2 of 1982. After the implementation of the Rules of Court 2012, only Order 11 has been used to govern service out of jurisdiction. The Court of Appeal in Match Plan Sendirian Berhad and William D. Sinrich had referred to the Malayan Banking Berhad case and took pains to set out how Order 11 of the Rules of High Court and Section 23(1) of the CJA are to be construed. Essentially, Section 23(1) of the CJA allows the courts to claim jurisdiction over 4 circumstances. When any of the criteria under Section 23(1) are met, the court already has jurisdiction to hear the case, and Rule 1 no longer plays a role in determining jurisdiction. In this situation, Rule 1 is simply a procedural step to facilitate service of the writ on the defendant abroad. However, if the circumstances under Section 23(1) do not apply, then Rule 1 becomes essential to establish the court's jurisdiction. The circumstances under Section 23(1) of the CJA and those under Rule 1 may of course overlap, and either one can be used to justify jurisdiction of the courts. These circumstances prescribed are an exhaustive list. The Federal Court in Petrodar operating in Namfat also agreed with the judgment in Match Plan, wherein both Order 11 Rule 1 and Section 23(1) of the CJA were set to confer jurisdiction to Malaysian courts over foreign defendants. In Goodness for Import and Export and Philip Morris Brand South, the federal court highlighted that once extraterritorial jurisdiction is conferred to the court under Section 23(1) of the CJA, Rule 1 becomes a mere procedural formality to enable service abroad. To sum it up, the crux of the matter is that non-compliance with Rule 1 will be fatal to the applicant's case in terms of a procedural requirement, even if the case falls within the scope of Section 23(1) of the CJA. Order 11 procedures still need to be followed if the defendant is a foreign person or entity. The substantive requirement of justifying to the courts that it is appropriate to exercise its jurisdiction, i.e., that the case falls within the circumstances prescribed in paragraphs A to M of Rule 1, is needed only when Section 23(1) of the CJA does not apply. The procedural requirement to obtain the leave of the court, however, is still required nevertheless. Rule 2 allows the court to grant leave for service out of jurisdiction where a contract contains a clause consenting to the Malaysian court's jurisdiction. Rule 3 specifies that a notice of a writ for service out of jurisdiction should be in Form 7. Order 11 Rule 4 details the application process for obtaining leave to serve a writ out of jurisdiction. It requires the submission of an affidavit under Form 8. The affidavit must contain the grounds for the application, confirm that the applicant has a good cause of action, and must indicate where the foreign defendant might be located. Rule 4.2 requires that the applicant show the court that the case is a proper one for service out of jurisdiction. To establish this, firstly, the case must fall within the paragraphs of Rule 1 or Section 23(1) of the CJA. Secondly, the claim has a sufficient degree of merit. It is to be highlighted, following the federal court in Joseph Lantip and Unilever PLC, that the primary consideration at the leave stage is whether the court should grant leave to issue the writ out of jurisdiction. A sufficient degree of merit simply means the plaintiff has a good arguable case. He does not have to prove his case will in fact succeed. Thirdly, the issue of forum convenience. In the Spiliada, it was stated that the court must be shown to be the appropriate forum to try the case, even when jurisdiction has been founded as of right. It must be the forum most suited to secure remedies or justice. Generally, a stay is only granted to the defendant if there is clearly another, more appropriate forum available where the case can be better tried, considering the interests of all parties and of justice. Is propounded by the Supreme Court in the American Express Bank case. If a defendant applies to stay proceedings based on forum non-convenience, they must prove that another forum is more appropriate. If the plaintiff seeks to serve a writ outside of Malaysia under Rule 1, it is the plaintiff who must show that the court that Malaysia is the most appropriate forum to hear the case. And finally, if the court is satisfied and approves the service of a notice for writ under Rule 4.3, an order in Form 9 will set a time limit by which the foreign defendant must respond.
In regards to Order 11, Rule 5, paragraphs 1, 2, and 3 outlines how to serve a notice of writ outside the jurisdiction, while paragraphs 4, 5, 6, and 7 explains how to prove this service where such service is done under Order 11, Rule 6 or Rule 7. If the defendant is in Singapore or Brunei, paragraph 8 provides for the method of service of notice of a writ out of the jurisdiction without going through the official channels. In the case of Fiden Electrical Engineering, the High Court ruled that as the method of service was not in accordance with Japanese law, there was a failure to comply with the then rules of High Court Order 11 Rule 6.2b and Order 11 Rule 5.2. Accordingly, the service of the process was set aside. This case clearly highlights the application of Rule 5.2, wherein service out of jurisdiction cannot be contrary to the law of that country. In a similar spirit, Rule 5.3 explains that a service of writ need only be served to the defendant in accordance with the law of his country. In Ma Bun Lan, the court held that a notice of writ which is to be served out of jurisdiction need not be served personally on the person required to be served, as long as it's served on him in accordance with the law of the country in which service is effected. The court in this case also went on to discuss the word may in Rule 5.8, stating that it should be taken in its natural sense, that is permissive and not mandatory or obligatory. Thus, it merely gave the plaintiff an option to serve, should he so desire, the notice of writ of summons to be served out of jurisdiction and the writ of summons together with the statement of claim to the defendant in the mode as stated in the provision. Rule 6 governs service through foreign governments or judicial authorities in countries where civil procedure conventions exist and provides options when no such conventions apply. The rationale behind the specific procedure for service of the notice of writ in countries where there's no civil procedure convention was discussed in Afro-Continental Nigeria Limited, where the court held that any exercise of judicial powers by our courts beyond their territorial limits would amount to an exercise of sovereignty in that other country, which can only be done with the consent of the other country. In Malaysia, the court in Sung Kyong International Incorporation held that if the other country is not a party to a civil procedure convention, then the method of service must comply with the procedure in Rule 6(2). Moving on to Rule 7. Rule 7 governs the service of a writ in specific cases where the defendant is a high contracting party to an international treaty, such as the Warsaw Convention. Rule 8, on the other hand, mandates that plaintiffs undertake responsibility for any expenses incurred by the minister in the service process abroad. And now, for the last rule in Order 11, Rule 9. Rule 9 permits service of an originating summons out of jurisdiction with the court's leave. It aligns with Rule 1, which limits service to cases with a clear Malaysian connection. Rule 9(4) extends the same requirements for supporting affidavits as required under Rule 4. In Gabong Trading Sdn Berhad, the issue was whether service of a summons on a foreign company without court leave under Order 11, Rule 9(4) of the Rules of Court was valid. The High Court ruled that the specific provisions of the Companies Act 1965, Section 339C, and Winding Up Rules, Rule 18, which governs service on foreign companies, took precedence over the general rule requiring leave. These provisions provided a valid method of service, making the summons valid even without court leave. The court concluded that the service was not null.
So, Ute, I was reading about serving out of jurisdiction in Singapore, and it all starts with the principles from the Spiliada case. Have you heard about that?
As a matter of fact, I have my notes on it. Let me look it up real quick. So, apparently in this case, Lord Geoff set out three main principles for service out of jurisdiction. He started off by saying that the plaintiff has to show that Singapore is the natural forum, and secondly, the process operates within a judicial discretion, but it's still bound by the statutory language of a proper case for serving out of jurisdictions. And lastly, sometimes service out of jurisdiction might even seem exorbitant in certain situations.
Right. It's interesting that Singapore also made some big changes recently. The new Rules of Court 2021, or ROC 2021, for the General Division of the High Court came into effect on April 1st, 2022. Apparently, the goal was to modernize and streamline the litigation process. This reformation moved service out of jurisdiction from Order 11 of the Rules of Court 2014 to Order 8 of the new ROC 2021, with some major updates on how it's applied.
Exactly. So Order 8 Rule 1 now says that any court document, including an originating process, can be served out of Singapore with court approval. But this can only happen if the court has jurisdiction or is the appropriate court to handle the case. This new wording is quite different from the old ROC 2020.
Right, it's a pretty significant shift. For instance, in Zoom Communications Limited and Broadcast Solutions Private Limited, before the 2021 changes, plaintiffs had to meet three specific requirements for leave to serve a writ out of jurisdiction. First, the claim had to fall under one of the heads listed in Order 11, Rule 1 of the now revoked 2014 rules. Second, the claim had to have a certain degree of merit. And third, Singapore needed to be the proper forum for the trial.
Correct. So those three requirements are still applied in Malaysia today. But in Singapore, unlike in the past, ROC 2021 has completely removed the exhaustive list of grounds for assuming jurisdiction over a non-resident defendant. However, Order 8 Rule 1 still requires leave from the court for service out of jurisdiction.
Right, but actually there's an exception. According to Rule 1.3, if the contract between the parties allows for service out of Singapore, then leave from the court isn't needed. In the 2023 case, NW Corp Private Limited and HK Petroleum Enterprises Corporation Limited, they clarified that if a foreign defendant agrees to accept service of a Singaporean process, it's implied that they consent to service out of Singapore.
Okay, that makes sense. Also, Order 8 Rule 2 is not just a straightforward rule for serving out. It has to be read together with Rule 3, 4, and 5. So each rule outlines specific methods based on where the defendant is located. Could be Malaysia, Brunei, other jurisdictions, or countries under the Warsaw Convention.
True. Order 8 Rule 1 also has two main grounds for the court's approval. One is about establishing that Singapore has jurisdiction. An example would be through the Choice of Courts Agreement Act 2016, which brings in the Hague Convention on Choice of Court Agreements. Under this act, if parties agree to resolve their disputes in a specific country's courts, Singapore has to respect that agreement unless it's invalid.
Right. Alternatively, the second ground is about proving that Singapore is the appropriate court or foreign convenience for the proceedings. So the ROC 2021 does away with listing specific jurisdictional gateways, so a claimant doesn't have to fit into certain categories. They just need to show why Singapore is the right place to handle the case.
That's a huge change. And the Choice of Courts Agreement Act, along with the ROC 2021, works hand in hand with the Supreme Court practice directions. Practice Direction 63.3D, for example, reinforces respecting a contractual choice of jurisdiction when Singapore is the chosen forum, which aligns with the court's obligation to uphold these agreements.
Precisely. And if someone needs to prove that Singapore is the right forum, the Supreme Court Practice Direction 63.2 outlines a few key factors. Claimants now have to show there's good and arguable case for jurisdiction. Singapore is the appropriate forum, and there's a serious question to be tried.
I like how the practice directions supplements the ROC 2021. Practice Direction 63.3 actually includes 20 factors to help establish a good and arguable case. And these factors are non-exhaustive, unlike before. The recent case of Cheong Jun Yung and Three Arrows Capital, they highlighted that the previous use of an exhaustive list under Order 11 Rule 1 of the revoked 2014 rules no longer applies.
Exactly. So Singapore's updated rules allow a lot more flexibility than the older ones, which required fitting into very strict set guidelines. So the 20 factors listed in the practice direction can cover various scenarios, ensuring the court can adapt to the specifics of each cases.
Makes perfect sense. Thanks for breaking this down with me, Uday. Singapore's approach is definitely more adaptable now, and I think I understand the updates a lot better.
Anytime, Faris. It's fascinating to see how these rules keep evolving to accommodate the complexities of cross-border cases.
Comparing the law in Malaysia and Singapore, one clear stark difference is that the circumstances prescribed under the Malaysian ROC and those under Section 23(1) of the CJA is an exhaustive and fixed list of grounds which must be met in order for the court to obtain jurisdiction, while there are no specific circumstances provided for under the Singaporean ROC, and those in the practice directions are a non-exhaustive list which need not be necessarily met to establish jurisdiction. Additionally, the requirement to obtain leave of the court prior to service of a notice out of jurisdiction is mandatory with almost no exception in Malaysia. The one exception was established by a case law, Gabung Trading, as discussed earlier, provided an exception due to the specific statutory provisions under the Companies Act 1965 and the Companies Winding Up Rules 1972, which set out a different procedure for serving documents on a foreign company in winding up cases. In this instance, there was only an exception because the court found that the Companies Act and winding up rules had more specific rules and a clear alternative method that override the general procedural requirement under the rules of court. In Singapore, on the other hand, leave of the court is necessary, with the exception of when an agreement itself specifies that Singapore courts shall have jurisdiction as stated in the ROC 2021 itself. Despite the differences, it is commendable that both Singapore and Malaysia respect the principles of international comity. Comity was clearly taken into account within the Singapore ROC by way of honoring the principle of foreign convenience in delineating the best jurisdiction to hear a dispute in cases of conflicting jurisdiction. Similarly, in Malaysia, Rule 4.2, which requires the applicant to show the case is a proper one for service out of jurisdiction, also mirrors the same principle of foreign convenience. In addition to that, the Singaporean ROC and Malaysian ROC both state that service of an originating process out of jurisdiction cannot be contrary to the laws of foreign country. In view of the laws and procedures in Malaysia and Singapore, Malaysia could benefit from observing Singapore's approach to service out of jurisdiction. Firstly, Malaysia could remove the heads as enunciated under Order 11, Rule 1A to M, and restructure this exhaustive list into non-exhaustive lists in a practice direction. Secondly, by adopting similar wording to Singapore's gateways under PD 63 3A to T, Malaysia could cover a comprehensive range of connecting factors as these subparagraphs effectively address most situations with a sufficient nexus to Singapore and nevertheless maintain it as non-rigid lists. Thirdly, the Malaysian ROC 2012 could be supplemented with the drafting of another provision within the practice direction, which provides an alternative avenue for the plaintiff to either establish a case that falls within the non exhaustive list or whether Malaysia is a forum convenience. A scholar argued that conceptual and practical problems would have arisen had the mechanisms for asserting the service out of jurisdiction under ROC 2021 had been reformed in such a way whereby the circumstances were removed from the equation altogether and the appropriateness of the Singapore court hinged solely on it being forum convenience. An alternative avenue would allow greater flexibility for the plaintiff to establish jurisdiction whilst at the same time respecting the jurisdictional boundaries and legal interests of other nations.
Now that we've perused the multiple case laws that helps to develop the Malaysian and Singaporean's jurisdiction when it comes to the matter of a service of a writ out of jurisdiction, what exactly can we infer from all of this? Allow me to indulge you. Comparison that can be drawn between Malaysia's ROC 2012 and Singapore's now revoked ROC 2014 and the current ROC 2021 tells us one thing specifically. What it tells us is that Malaysia's approach to the subject matter is much rigid in comparison, with our exhaustive criteria, whereas Singapore is much more flexible when it comes to dealing with this matter, enjoying a non-exhaustive approach for service out of jurisdiction. While Malaysia mandates court leave with limited exceptions, Singapore allows exceptions parties agree to its jurisdiction. Now, bear in mind that both in its own way upholds the principles of foreign convenience and international committee. However, it is undisputable that Malaysia might have a thing or two to learn from its neighboring country. Malaysia could definitely improve by adopting a similar flexible framework, same to Singapore, enhancing jurisdictional adaptability and streamlining cross-border litigation.